Hello, and welcome back. The two gentlemen who will be sharing their expertise with us during this next session really need no introduction. Their session at last year's event was among the highest rated, so there was no question that they would be invited back. Professor Paul Watchman, Special Legal Advisor to the United Nations Environment Program, and Paul Clements Hunt, Director at Mishkondareya. Mishkondareya are often referred to as the godfathers of, these two gentlemen are often referred to as the godfathers of legal ESG. Professor Watchman was among the authors of the original Freshfields report in October of 2005, and Paul Hunt was among the small team of people at the United Nations who coined the term ESG way back in 2004. Last year, they were with us to discuss Chasing the Dragon, focusing on the rise of the ESG law firm. This year, they are here to discuss and to launch the much anticipated follow-on report, which will be released next week, called Riding the Dragon. We pre-recorded this session due to the very busy schedules of these two gentlemen. But to the extent their location and connection allows today, they will try to join us live at the conclusion of this pre-recorded portion in order to take questions and comments. Please enjoy this conversation with the Pauls, as I affectionately refer to them. Go ahead and roll the tape. Excited to have both of you join us today for this conversation. Thank you so much for taking the time to pre-record, given your really busy schedules. Last year at the Legal ESG Summit, this session was one of the most popular, so there was no question that we absolutely had to have you two gentlemen back to talk about where we are today, particularly compared to a year ago. A year ago, we spent our session talking about Chasing the Dragon, which was a new report that your team had recently published about the state of ESG in the legal profession. Tell me a little bit about what prompted that initial research and the findings, and then we'll get to the most recent report, which is just about to be published. Professor Paul, do you want to comment first?
Yeah, if I may. Paul and I have been in this space for more than 20 years now, and we tend to know who's active and who's not. And about 2016, you'd have found very, very few law firms offering ESG type services or climate change services. You'd have found very few lawyers specializing in those areas and offering advice in those areas. From 2016 onwards, there's a build-up, particularly in the City of London, particularly in the US, but globally, of firms saying, we now have ESG practices, we talk about ESG and impact, and why talk about things that don't have impact? Of course you talk about things with impact. But the whole thing was, we're now at that time, I wanted to look beneath the surface to find out actually what was happening with these law firms. And at that time, I think it was about 55, Paul, wasn't it, law firms we looked at globally, but with more of an accent on the US, Europe, and less in terms of Africa and Asia, etc. Now, the new report, as Paul will explain, deals with it more globally. It's a much wider, more in-depth report. But so the report was divided into two parts. One was to look at why these firms, and I remember one day in about 2018-19, when 4 US law firms opened up ESG practices in one day, and I thought, goodness, this is like Pound Stretcher or one of these bargain basement stores that, you know, buy one, get some more advice free. And so Paul and I agreed to do a dive to look at it. We selected a number of firms and then we spread it out. We intentionally have not ranked law firms because we believe that it's not for us. We don't believe we've got the skill set or the resources. We also think that it could be negative, and we don't want to be negative. We actually think that climate change and ESG law are the most important challenges to happen to the legal profession in 100 years at least. certainly in my lifetime, this is changing, revolutionizing the way in which law firms operate, but also accountants and consultants, etc. You'll have seen in newspapers things like discussing how we recruit people with ESG, and the accountants saying they're going to spend billions, and the ESG war out there. Well, the simple question that I often ask is, how do you train people when you've got no one who is trained to train them? And that is something that needs to be looked at. But so just going back for a moment, we're looking then at the tsunami of legislation, policy, and difficulties coming down the line. And we're seeing that just now with the multi-standard disclosure requirements of the US, of the UK, of Europe, and other countries, which is a bit of a mess. So we're looking at how clients are impacted and what they expect from the law firms. And a number of clients do expect value alignment. And so looking at the supply chain, which I'm sure we'll come on to in some detail, looking at the value chain and supply chain, we can actually see clients looking for the lawyers to behave in a certain way. And I remember reading something from Walmart, of all people, saying, don't do it just because you can, to the lawyers, which means you don't have to be a pit bull. You don't have to go in biting and savaging people. Let's see if we can do something constructive. The second part, which I think is really important, is the culture of law firms is shifting. If you look at some of the major law firms, you can see that they've set up task force, various committees on diversity, exclusion, and equity. And I think also we're looking at this as a recruitment retention matter. And Alan Jope of Unilever said recently, and we'll come back to the irony of Unilever and washing powder in a moment, but and greenwashing. But he said that ESG was the most powerful recruitment tool he had. And I think a lot of lawyers are attracted to law firms for that ability to practice in this area and to move beyond what used to be thought as a geopolitical no-go area to one where we're now looking at the impacts of investing and advising in Russia. And one of the things we were talking about prior to just doing this was the question of employees, where major law firms, accountants, businesses have come out of Russia, what they're doing in terms of a just transition for those employees. So I'll stop now and let Paul or come in, or if you've got another question.
So Paul, tell me a little bit more about the key findings of the Chasing the Dragon report, that original report a couple of years ago.
Sure, Pam. And listen, I want to just maybe add to what Paul said also in terms of, let's call it the ignition point for Chasing the Dragon, the original document in March 2021. I mean, it came from a UN process. The UN, Paul and myself worked with the UN and with Judge Professor Mervyn King from South Africa to look at the business response to the pandemic. Okay, so what then happened was we looked at the unbelievably important role of professional services, as Paul said, you know, the accountants, the consultants, the legal world. And off the back of that, we decided to dig down into the legal world as the first of the professional services. So the start point was a UN process, as Paul only knows too well. But where we came with Chasing was, I think we said back in March 21 that the tectonic plates were shifting in the rise of ESG law. And some of the key findings was the generational shift in terms of lawyers, in terms of the talent coming into the legal world. It was a lot around culture, the culture of law firms, the whole diversity and inclusion piece. We were seeing that to the fore. So it's identification of talent, retention of talent. I think what we also saw in Chasing very distinctly was this growing appreciation that ESG, if used correctly by law firms, perhaps at the systemic and the portfolio and the operational level to look at what they were doing was a really powerful lens to understand how risk, the nature of risk was changing, and how different risks on a warming planet with a growing population were converging. So in terms of, I think the key takeaways for me from chasing were what Paul said. It was, with few exceptions, law came late to the ESG party, right? There was a whole pile of drivers, one of that being the investment world and things like the UN Principles for Responsible Investment. By 2016, you had sort of approaching $100 trillion of assets. You had much more engagement for the financial system in terms of renegotiating their social license to operate. So, big, powerful clients of law were looking at these issues in real depth. And around, as Paul said, around 2016, law woke up, the leaders stepped in. By 2017, 18, 19, everyone was taking ESG into account. Now, I think one of the challenges, and we'll come on to riding the dragon, is, some law firms are hinging on the boundary of claiming too much on ESG with not a lot to back it up. And let's say 5 years, 6 years into the process of the real engagement by law in ESG, I think that's dangerous ground. So what we're seeing in the latest report, Riding the Dragon, the Rise of ESG Law 2, is that in catch-up, law firms cannot go too far, right? And that the intensity of policy and regulatory change now is such that the dial is moving really, really quickly, and that combined challenge of attracting talent which knows ESG, retaining them, and actually delivering the services is being demanded by the markets. It's being demanded by general counsel across the block. And the ability to actually provide the services, you've got to have an alignment between what your law firm is saying and what it can actually do on ESG. But we'll come back to it. Look, that's the big takeaway. In my head, we've gone from the tectonic plates are shifting for law to the actual core of the earth is moving as, financial regulators, prudential oversight, as it gets buried in the capital markets, it's going into the roles and responsibilities of directors. People are needing really good, hard-edged legal advice around ESG. And the market is only just beginning to provide it, and not everybody is. I hope that's fair enough, Paul.
Could I come in here, Pam, just to mention a trend that I've noticed, and that's the internationalization of ESG at regulatory level, at the level of the courts, and at the level of plaintiffs and NGOs. So what you've got is, if I start with the regulators, you notice that the DOJ in the States and the SEC, they're talking to the Competition Markets Authority in the UK, who are talking to the ASA, the Advertising Standards Agency in the UK, who are talking to their Dutch counterparts, they're talking to their German counterparts. So on the regulatory side, there's a whole sharing of information amongst regulators that I've never seen before. And I would say the same in terms of plaintiffs and NGOs. I mean, this willingness to share precedents, policy, practice, you can see it in the Chancery Lane project, where they're providing a games book, if you like. And the fact is that they're sharing precedents, but also with NGOs, they're looking at different forum. They're looking at, would France be better for this? And Paul and I might mention, or someone will mention, the Lafarge case, which is really important because it's extending the law in relation to corporate complicity in a way in which has not been done before. And this is really dynamic stuff. There's a lot of dynamic law coming out of this.
Yeah, Paul, can I add to that as well in terms of that shift in the focus of the policymakers and regulators? What you're also seeing in terms of a specific look at ESG are the prudential oversight regulators across different markets coming in. So, the Bank for International Settlements, the Basel Commission on Banking Supervision, the International Organization of Security Commissioners, all are beginning now to look at ESG in a much more refined way. So that's coming into the very heart of prudential oversight. That feeds into capital markets, that feeds into the publicly traded companies, that feeds into the board. You're beginning to find directors of the publicly listed companies asking from counsel, internal and external, what does this mean in terms of roles and duties and responsibilities for directors of some of the biggest companies in the world? The point Paul made in terms of Lafarge, which essentially out of the French Supreme Court a couple of months ago was that the allegation of financing terrorism, in which money was paid to ISIS in Syria to keep a plant open beyond the point at which a lot of other people had withdrawn. This comes actually down to the role of the individual directors and the offices. And I think, Paul, once it becomes personal like that, it's both about your company brand and reputation, but that's getting translated to individuals, and that's a hyper concern. And so whether it's Lafarge or whether it's the case going through the UK Supreme Court now, BHP Billiton and Vale, the tailings disaster from I think it was 2016, there's a $5.2 billion sort of class action hovering on that now. That's all changing, but I think it's the flow from normative and perhaps the softer edge of regulation to very hard finance and market regulation, and particularly in climate change. Paul, I think we agree.
I was just going to add about judges. I mean, some of the jurisprudence that's coming out now, I call a shift in jurisprudence that I've not seen before. Things like intergenerational justice, that is a very, very important concept. You can see international laws or soft law, if you like, the sort of ruggy business and human rights guidance, being interpreted by judges like this hard law. And the judges themselves coming and giving papers, writing articles, saying, I think after the pandemic, there should be more emphasis on employment. There should be another E. Now, we're also seeing a backlash against ESG, particularly from the southern states, etc. And it was quite funny reading it the other day, because I've always regarded fiduciary duties as something that's organic. It grows over time. And it's a common law concept, basically, where two parties are in an unequal relationship. You've got the beneficiaries and you've got the trustees, etc. And the thing about it is, what they're proposing, don't look at ESG, is almost a breach. It is a breach of fiduciary duties, because why wouldn't you look at reputational damage? Companies are now about their reputation. That's why we've got all this new purpose stuff. Let's make a statement of what we are as a company. And I think that's really important to see those changes happening in the courts, because the judges are not renowned for being brave or courageous. They're actually renowned for falling at fences. But I think in all jurisdictions that we've looked at, there is this movement, whether it's Holland, whether it's America, whether it's the UK, whether it's Australia. And there was another one the other day about revoking a license or not implementing a license where there'd been improper consultation or hadn't been proper consultation. So we are in the throes of a maelstrom. And I think law firms really need to decide, if we're going to do it, let's do it right, do the right thing.
And Pam, can I add to that just briefly?
Yes.
I can't resist. But look, as Paul said, there's a huge amount of white noise and confusion. I see it as the sort of the Klondike of the ESG era, in that different actors are making money. But if you go back to basics, if you go back to 2004, when ESG was coined, and then the Freshfields report, which looked at 9 capital market jurisdictions and the reality of fiduciary law in those jurisdictions, you can bring ESG back to a basic, which is, within capitalism, in terms of risk and reward, you've got to be able to ask, is that a material risk? And if the answer is yes, it is a material risk, well, What are you as a company? What is your directors doing to deal with that in terms of fulfilling your roles and duties within the company? What does that mean for the fiduciary side of the argument? So you can always take ESG back to the simplest level. It's about material risk. You understand that. You can then see new opportunities in the upside. And how does that management of material risk, affect your fiduciary duties? So I think that's, as Paul said, that's an argument which, if you're operating in a free market and you believe in capitalism, whether it's extractive, the model for the last 250 years, or where we're heading regenerative, you've got to be able to ask, as an investor of your company, is that risk material? How will it affect the investment? What's the company doing about it? I think it's a really powerful narrowing down of what ESG ultimately was set out to do, which was to move culture and make sure that investors were having a different conversation and looking at a broader range of risks.
Right. And I would add to that, not just investors asking themselves that question, but also directors and officers and, in our case, firm management.
Yeah.
So given this tectonic shift, and I think you described it, Paul, as the core of the earth is moving, how did you change the parameters or enhance the parameters of the research being done for this report, which is called Riding the Dragon? What's different from the parameters of Chasing the Dragon to Riding the Dragon?
Okay, two points. We've extended from 55 law firms to 100 in terms of the research process. The research process itself was the same. It was looking at public available material across the law firms in terms of both the professional staff, the services offered, the capabilities, and trying to match up what was said with what is actually being done. So we've extended to 100 companies. I think, again, where there's a difference is Chasing was very much, let's say it was UK, European, North American centric. In Riding, we've got views and opinions coming in from Brazil, South Africa, India, Hong Kong, SAR, obviously from Australia. And it's a much and Brazil, it's a much richer mix of opinions. Now, again, in terms of part of the thrust of the document, and I think it plays to Paul's point, right? We've got some fantastic pieces from expert contributors which look to that question of the culture of law, right? And also the purpose of law. So we're also importing some, let's say, really academic but practical assessments of where law is changing. And to Paul's point, which maybe, Paul, you'll come back in on this again, but that idea that there is this shift in the way the judiciary in different jurisdictions are looking at it. That's the big packaging. When you get down into the nitty gritty, I think we've got quite a focus on the rise in litigation, or public purpose litigation, whether it's climate, whether it's human rights in the supply chain, whether it's any of those complicated issues, and the role of third-party funding. I mean, I think it's a model well understood and accepted, perhaps in North America and the US. That's coming in to the UK in particular in a much more full-bore way. And I think one of the most telling examples for me, in terms of a concrete example, and Paul, I'd love you to play off this, is we're doing some work with the moment, and we've got a wonderful piece from the Brazilian Federal Police Forensic Accounting Department. And that's where, regulators and agencies like that are beginning to look where there's perhaps been an illegal transgression in their domestic setting by an international company, and this idea that you can take both criminal prosecution but also civil prosecution, and you can take it to courts and other jurisdictions. So it's that idea that it's not just let's say Western NGOs looking down the supply chain and seeing issues and problems, but it's more a case of really proactive action by other agencies in their own jurisdiction saying, wait a minute, let's go to the illegally cleared Amazon and see which international companies are beginning to benefit from whether it's agriculture or extractives, and what's the access to justice? What is the redress for actual communities? How do we use that combination of criminal law in our own countries, but also civil law in terms of wider jurisdictions, particularly where you've got the type of policy and regulatory changes in the EU, certainly some in the UK. But Paul, I think that's been one of the most accelerating shifts, is the ability to use public purpose litigation around the world to actually enable people to get access to justice, access to redress in a meaningful and sensible period of time. Paul?
Yes, I mean, I think the English courts, and for example, in the BP case and the most recent BHP Billington, are not supporting the old legal views of, there used to be an important legal view about the corporate veil, that the parent company would not be responsible for the actions and omissions of its foreign subsidiaries. Now, that's gone. We've also arguments about why can't you get justice in Brazil? Why this is a Brazilian issue? It might be a UK company, but it's a Brazilian issue. It has to be judged in Brazil. Again, the Court of Appeal is saying that is not a remedy. That is just kicking the can down the road, and we're not listening to that anymore. Now, these were two of the pillars of civil law. The other thing I would say is, I've been doing a little bit of a tour recently with Desiree Fixler, and I don't know how many of you know who Desiree Fixler is, but she's the whistleblower on the DWS ESG scandal, and it's already claimed one CEO, and the German police and the British police, the police force, have been involved, as well as the regulators like BaFin and SEC, etc. And basically what she alleged was that they were marketing products, financial products, that were not ESG compliant. Basically, it was old wine in new bottles. It was just the same stuff, and it had been relabeled, etc. So we're doing this talk about greenwashing, and my screen every morning, it just says greenwashing. Now, I'm a bit concerned. Greenwashing sounds like something nice. You go away to a spa weekend and someone would say, do you fancy a greenwash, sir? And, or madam. And there was a lovely thing with Unilever the other day, who were found to have greenwashed about their new improved Persil, their washing powder, which I thought was good, because the idea that you'd be washing with your own powder, but Unilever, who are one of the champions of ESG, one of the leading firms, for them to shoot themselves in the foot. And then there was a lovely case of a funeral director, I think down in Wales, who said that his coffins were more environmentally friendly than other coffins, and was said to be greenwashing, a very particular form of greenwashing. And I'm not sure where the complaint came from or who reported it. But the other thing about it is that companies are going to find it very difficult to survive these scandals. You can see with fast fashion now, there's been a lot of coverage in the Dutch newspapers about H&M, new labelling standards, etc. And I think that greenwashing will become a crime in itself. I mean, at the moment, what we're doing is we're putting fraud, advertising standards, or we're bringing in things. I think the most interesting one was the SEC are suing, I think it's Vale, in the relation to, again, the Brazilian case. It's a complete nightmare for these, well, obviously for the people who were affected, but for the mineral companies, because what they're saying is you misled the market about the safety of these mine tailings. So they're taking a different view. And so there's quite a lot of segmenting in, pushing in from different examples. And I think one of the things we're starting to see is not only is insurance becoming very much more expensive, particularly for directors and officers. That has changed and may not be available in many forms. And of course, a number of insurance companies have pulled out of the funding coal, for example, or covering coal. Although we did see again this week, three, I think Bank of America, JP Morgan and Morgan Stanley threatening to pull out of the Glasgow Alliance, Financial Alliance, because they think the standards the SEC are going to come out with are too exacting. Well, the answer to that is Deliveroo. Deliveroo was the worst IPO in the history of the English stock, the London Stock Exchange rather. And the thing about that is, if you two of those three banks were the principal banks, and 3 billion was wiped off their value when it went to market, because I believe they did, and I think this is completely valid, that they didn't focus enough on the ESG aspects, the zip economy, the rider safety, the unusual governance structure that was put in there. And by the time it came to the market, many of the principal asset managers and asset owners were saying, this is not for us.
And Paul, can I jump in as well, just to add to what you're saying? Look, so Paul and myself were, we were at the Cambridge Economic Crime Symposium, which is a major event, which is, I think, met for 39, coming up to 40 years. And we were asked to do a session on greenwashing, right? And it was a good and it was a long session. But that idea of, it's not just greenwashing, but it's the slide into, when is it willful ignorance? When does it become sort of malfeasance? When does it become criminal? And what that did in my mind was I sort of stood back, and I think there's a really interesting mismatch here, right? So the regulatory and policy edge in so many jurisdictions is hardening and hardening quickly around ESG, right? We see that. And I think the mismatch is that many complex multinationals in numerous sectors, right, with their international operations, a lot of the greenwashing at the start point boils down to language. And I don't know if people on the call are old enough to remember the World War II saying, loose lips sink ships, right? In my mind, there's a mismatch between how regulation is hardening and different authorities and exchanges are looking at the way companies are presenting themselves, right? And the use of language in marketing, right? And what that is creating, I think, is it's creating a sort of a cauldron where it's possible to greenwash without really knowing it. And again, there's an expectation from so many stakeholders, your customers, your clients, the public, the regulators, for better behavior writ large. Regulation is catching up with you, and the policy is moving quite quickly. But let's put it in simple terms. Marketing departments who use language loosely to capture hold of the zeitgeist, that's a claymore mine waiting to happen, right? Mm-hmm. And so there's so much change, there's so much shift that the ability for general counsel within large companies to have a handle on that is really challenging. And that's why, as Paul always says, if you're going to take ESG advice, it has to be good, it has to be experienced, it has to be deep in terms of its understanding. Paul?
Yeah, well, I would also say it has to be independent. One of the things that we've seen with a number of professional consultancies recently is becoming too close to the client, basically. I mentioned Bain & Co have been suspended from bidding for UK government contracts for 3 years over the South African involvement. We will also see that with McKinsey, with the Purdue Pharma scandal in the States. So the important thing here is that when we look at what's happening, companies need to get a hold on what they need to protect themselves. And one of the things that I've been looking at, and Paul and I have been discussing, partly with your new role, which you can explain in a moment, but one of the things that I've been looking at is what happens when an inspector calls? What happens when a company is accused of greenwashing and it's severe enough for the police to be involved, for regulators to come in, to seize papers, to interview staff about prosecution, etc. And all I have to say is the word Dieselgate, and everyone gets it. You know, how many billions did that cost the car manufacturers? And when you think about how that may have been seen as a justifiable market practice, that everyone's doing it. My father was a policeman in Scotland, and he always said that was always what burglars said when they caught them. Why are you picking us? Everyone's doing it. And I think the thing about when you look at some of the cases that are happening, it's moving into a legal arena in a way in which it didn't before. And Paul's absolutely right. There used to be a trick question I used to ask when I was doing work on the Quera principles. Or on fiduciary duties or ESG investment. I would ask, in which department have you located it? And it's always a bad idea if they said any department, they should say it's across. But some of them said, oh, it's in PR. And I said, it's in PR. Why is it in PR? Because it's about projecting the company. I said, no, it's a little bit more important than PR. And the other thing I was taught by a very close friend of mine who used to be doing all this stuff at Barclays many years ago. You remember Chris, Paul, and he said to me, when you're looking at these projects and people are saying they're doing social and environmental assessment of impact, just count the bodies and count the number of transactions. He said, because unless you have enough people to monitor it going in and to monitor it as it goes forward, then it's just lip service.
Paul, just on that as an anecdotal footnote before coming back to stuff, but Chris Bray of Barclays, I remember him back in the early noughties when the Equator Principles were being formed by the International Finance Corporation. And they were originally going to be called the Greenwich Principles until Chris Bray of Barclays pointed out that that was one letter short of greenwash, and that's back in 2001 too. So Chris was ahead of his time. I hope he's listening to this, but he did some fantastic work. But look, Paul, on that issue and the movement, perhaps the role of law firms and legal firms in the ESG environment and in the whole sustainability thing, I think you're absolutely right. I think that's because of the hardening edge policy regulation. That's where it's heading. There's no question. And I would also say that there are, one of the things that comes out of riding the dragon is there is real questioning inside law firms, not just about the role of the law firm, but the role of law. And that's being driven by a new generation of lawyers. Now, look, I feel happy and privileged to have joined a UK law firm 6 weeks ago to help them build a sustainability climate operation. That's Mishcon de Rea, and the part of the firm that I'm in is Mishcon Purpose. And one of the remarkable things which shimmies with riding the dragon I've seen in the last 6 weeks is the younger lawyers in here are really driving the agenda and asking about it, and they're informed on climate change, and they are they're really pushing in terms of that whole idea of, there has to be a purpose. And that's why I think Mishcon Purpose is not a bad name in terms of looking at the issues. But that generational shift is fundamental. And I think some of perhaps the older, more mature lawyers, are learning quickly just how ingrained that is and how the zeitgeist has changed. But also asking the bigger question. So one other thing which is fascinating in Riding the Dragon is we've worked with Dr. Roger Miles, who's looked at conduct and behavior in the financial services. And we've asked him to sort of take the lens that he's used over the past 15 years since the crash to look at financial services and apply that lens to what are the lessons that law firms and the legal community can use to think about internal conduct, to think about culture, begin to shift it. And all I'm saying is I think it's a marvelous piece, but it's that fascinating question. What shifts culture? How do you shift conduct? How do you get it right?
And I think also, if I could just add about accountants now, I mean, the accountants are starting to build up their legal capacity quite markedly. And one thing they've got that law firms need to get is multidisciplinary skills. And that was why I was so pleased when I heard that Paul had joined a law firm, because going into being a policy person or an ambassador with different companies wouldn't have got that bridge. And when I say I believe it's holistic, I believe it's across your practices, whether it be real estate, whether it be white collar, whether it be insurance, etc. But it's also big data. It's also economics. It's also policy shaping. And this is where law firms, unless they're just going to be pushed aside, and I know that Deloitte's income is 10 times what the Kirtland Ellis is, and Kirtland Ellis are meant to be the most profitable firm in the world. But the whole thing about it is that you do need multidisciplinary groups, and you do need people working across not only firms in London, office in London, but you've got now, I think Denton Hall have got so many offices in China, Africa, etc. You just look at the way in which law is expanding. The other thing I will say, and this is a genuine plea to law firms, if you're doing large projects in Africa, in Asia, in developing countries, develop the legal skills there. Do not ship it back to New York or London just because it can be done there. Build up, because you have to, if we look at the challenge of Africa in the next 20 years, I think that is going to be such an exciting place. But if we want to continue with Smithsonian economics, if we want to understand that the invisible hand is guided by moral sentiment, if we want to have that sort of thing going, and we need to bring in almost that Max Weber idea of predictability of return, etc. And that's where the rule of law becomes really important. You do not wish countries that do not have that infrastructure that will enable you to do it. But I have seen too often, in my experience, carpetbagging is going a bit far. But I mean, there is this view that what happens is some plaintiff law firms and some large law firms go in and they'll do a project in Africa and they'll just take the money out. And I think they've got a responsibility to develop legal skills in those countries.
Paul Clements-Hunt, I would love to hear from you. What was disappointing, if anything, to you in the findings of the Riding the Dragon report?
One statistic, which was of the 100 companies assessed in terms of their publicly available information, where there is, look, there's, without putting rose-colored spectacles on it, there's tremendous work and shift, and there's great advances. But we reckon between 25 and 30% of the companies we looked at have no way of publicly verifying that what they say they're doing on ESG, they're doing. And it's that gap which is challenging. And I think it really needs internal reflection. So in terms of, both the qualitative side and the quantitative side, and the way we conducted the research and the research team, that statistic really stood out for me, that, you could still have that gap between firms claiming to be able to do A, B, C, D, and E on the ESG or the sustainability front, but actually, when you look a little bit deeper, the sort of confirmation of that is pretty thin. Let me put it that way.
Yeah, one of the examples I would give you is business and human rights. And we're now moving on to doing human rights due diligence in a more in-depth way than we've had in the past. I think, and I'd be surprised if many of the lawyers who are representing their firms on business and human rights, there are some, but I'd be surprised if there's many who have actually done this sort of work before, who've actually, I mean, Paul and I worked with John Ruggie and with others on business and human rights for many years. And the people, we're not, people don't just spring up. I know it's not taught undergraduate level and there's some postgraduate level teaching, and I'm trying to talk to law societies and the IBA, etc., about how we deal with this. But it is surprising to me that when you actually provide a service, that you are putting people out there without any track record. And one of the things is you might say, okay, someone's quite young and just come up to it. And I mentor, and Paul mentors, many young lawyers and young professionals in the ESG space. And they'll talk to me about bonds, or they'll talk to me about various things that are happening within their firm. But what does surprise me is I'm seeing, and I'm going to put it very crudely, I'm seeing a lot of retread former tobacco defence lawyers starting to project himself as business and human rights lawyers. And as I said to one of them I know very well over many years, where he has represented tobacco companies, etc. I said to him, the only way you become a business and human rights lawyer is if you put the prefix IN before the human, and then we can agree on what it is. But it is disappointing. At the same time, I would say that there is such great things happening. I mean, I'm a big fan of some of the work being done by Magic Circle firms, especially two of them. I'm a great fan of how some of the American firms are doing this. And I remember some years ago, back 2004, 2005, I used to go to the American Bar Association and the IBA conferences and used to talk about carbon trading, carbon offsetting, etc. And this was brand new, absolutely brand new. And I've got a feeling that for a lot of law firms, it's still brand new. You know, the perils of, carbon offsetting or carbon capture or direct air capture, etc. These are things where you have to develop, and it's not just enough with bringing out green bonds or blue bonds. They have to actually have the right mechanisms within them. And I just see some of them as just straightforward vanilla bonds that have got nothing like that. But in saying that, I'm also seeing groups like the Gold Council starting to look at metals, etc. And I'm starting to see bodies like Tesco coming up with supply chain issues. And one of the things I will say, get it off my chest, the supply chain scope 3 is nowhere as near difficult as people are making out. And regulators will allow a period of time where the companies work together to provide that information in a robust way. But what they're saying now, we can't do it. Well, if you can't do it and 85% of your emissions are scope 3, what does that tell you about your contribution? It's nothing. It tells you nothing. So I think there's a need for people to step back. I just wish that I would get an invite to just sit down with the CEOs of a number of major banks or asset owners and just sort of say, right, okay, let's talk about how difficult this is. And bring in the general, one thing we haven't said, Paul, general counsel. I see a huge sea change in the way general counsel are grasping this opportunity. And they see it as important, not only to be the keeper of the moral compass of the company, the purpose of the company, but also in terms of how it's going to influence the way in which the company is seen in society and develops.
And Paul, just on that, I've had the privilege of over the last few weeks engaging with a lot of general counsels in different forums and different sectors, and I think you're 100% right that if you accept the premise that because of the changes in the planet, whether it's climate or ecosystems or any of those major systems, that the nature of risk is changing, and that the simple formulation is, with 8 billion people on a warming planet, in terms of your company, if as a GC you cannot take the board through the labyrinth of, it's not just risk changing, it's the nature of risk changing. We're seeing complex converging systemic risk come together, and that affects many businesses in different ways. As a GC, that's it's a free card to work with the board to get that face time to say, look, from a legal perspective, in terms of roles and responsibilities of directors, we have to understand how the nature of risk is changing for our industry. We know our industry, but what we're seeing is this ESG gives you a slightly bigger radar screen to understand risk as it converges, as it changes, and at a different granular level and resolution. And I think you're right. I think the role of the GC, as heavy as the duties are in terms of reporting, disclosure, compliance, that this emergence of ESG is a powerful tool that boards can use to say, these are our material risks, these are the priorities, we know there are other risks, this is how we're going to deal with it, this is our robust narrative that we take to the market, and we defend it. If you use ESG materiality to build a prioritized framework, any board should be able to defend what they do across the environmental, the social, and if their governance is sound, they'll get to that point. So I think, yeah, the role of the GC is absolutely critical going forward, and we're also seeing that in riding the dragon. Pamela, you said to me, what was the most disappointing thing? Well, I know our time's moving on, but and Paul sees this every day. It is the generational shift in terms of whether they're law students or they're coming in as trainees or associates, that what I see increasingly across the piece is people really asking questions in terms of, what does my firm do? What does it believe in? What's its purpose, right? And I see that generational shift as being fundamental, just as important as Paul's mentioned the changes in the judiciary and the way they look at things. The new breed of lawyers, I mean, they might still be at university now, they might be qualifying, they might be going through the new, the 7-year process to qualify as a lawyer. If you haven't been through university, these types of things, phenomenal change. They've grown up with it. They've grown up with systemic risk. They've grown up with climate, COVID, the destruction of the ecosystems, and it's in their DNA. So they ask those fundamental questions. Paul, I don't think I'm overstating it, but that's my biggest positive takeaway from riding, is simply the generational shift. They will not put up with law firms that do not take these issues seriously.
Yeah, and I think when you were talking, I was reminded of the it's law students for climate accountability. And I don't know if you've seen the tables they produce, but one of the most interesting things about that is, obviously Gibson Dunn are one of the big defendant lawyers, etc. And they've got this slogan, "Done with done," which I thought was quite good. But at the same time, it's quite simplistic, because I was with Freshfields. I believe I moved to Darrell. I believe that Freshfields is a Magic Circle firm that represents everyone from plastics to chemicals to fossil fuels to banks, etc. Now, the thing about it is, you have to be willing to move the dial, and you have to be willing to stand up for processes. But if I look back, Paul, to the beginning of my career, gender inequality, it was awful. I think about 1% would be women partners. It's now up to about 18%, which is awful. But we need to move on that. In terms of sexuality, the whole the issues round about being gay, etc. I mean, the Philadelphia wasn't made up by someone. It was a real story, about a US lawyer in a US law firm. And, we look back at things like the Me Too movement, etc. We look back at the way in which the mental and physical health of lawyers was not protected. It was a matter of filling out these billable sheets in 6-minute intervals so that they could charge fees. It's the craziest system I've ever come across. I would not like my heart surgeon to be charging me in minute blocks. I would like him in and out quick and forget it. But I mean, I think the thing is, we do need to recognize that law firms have to change. The culture has to change. And the ones who prevail will be the ones who recognize this and provide a balanced opportunity for their own people and for their clients. And sometimes you have to, what do they say, talk truth to the powerful.
Paul, let me add one thing in terms of just my own experience in the last few weeks is, look, in my conversation with Mishcon Dorea before joining, one of the things that really impressed me was that when the company set up Purpose a couple of years ago, the partners went back to the actual constitutional deeds of the company and revised them in terms of aligning it with, the need for actually delivering positive social impact. And that to me was, it was a really positive flag to say that, Mishcon as a company was serious about this both internally and in terms of serving clients externally. So that's just it's a personal reflection.
So clearly there is reason for hope, right? Some of the things that Professor Paul just mentioned and your comments about the up and coming generation, I find just as promising, that the passion that they are showing, we all could learn a tremendous lesson from. So before we have one more minute, I would love to hear from you, Paul Clements Hunt. Where can people get the new Riding the Dragon report? When will it be released and how can people get their hands on it?
So Pam, it's being released today in line with the Legal ESG Summit,
Excellent.
And it's available, online, and I think there'll be lots of opportunities to access this. No question. So that's one thing. And listen, apart from the passion and apart from the good news and the generational shift, it's the mother of all business opportunities for law firms to, if you think it's going to take us 3.4 trillion to deliver the sustainable development goals, that's annually, right? It's gone up since the pandemic from 2.7 trillion to 3.4 trillion, right? That could you imagine that transformation taking place without lawyers, without the papers being redone, without the contracts, without the sustainable finance? It is a bonanza for any law firm that gets it right. That shift from extractive capitalism of the last 250 years to regenerative capitalism now. Law has to be at the very center of it.
Yep, it is the biggest business opportunity of our generation for sure, and lawyers should be leading the charge. They need our highest and best skills to get there. So I think we all are in agreement on that. I can't thank you two gentlemen enough for joining us today. I know our audience always appreciates it. And I believe that you are also going to join us live now, technology permitting, and we will take some Q&A. So thank you very much.
Looking forward. Thank you, Pam. It's fascinating. Hopefully we can come back next year if you want us.
Absolutely. Thank you.
Bye, Pam. Bye, Paul.
Bye-bye. And we are lucky enough, I think, to have both gentlemen with us. So we'll give it 1 minute. Hello, Paul. How are you? Oh, you're on mute, Paul Clements Hunt. And Professor Watchman, I see, just joined us. We'll give him a minute to turn his camera on and his microphone on. There he is. Wonderful. This is so fortunate that despite your travels and despite your unknown technical connection capabilities, we are able to have you live. There were a couple of questions that came in during your talk, which Paul dutifully answered already, but there are a couple that I'll pose to you live. A question about the ESG questionnaires that are coming into law firms from client organizations. Many of those questions do not reflect law firm governance realities, and that sort of forces us into a yes/no response. And those binary answers are not very informative, and they could perhaps be seen as greenwashing. Do you know of any efforts to make those questionnaires more uniform and perhaps even more appropriate for law firms and other professional service providers?
Can I come in here, because I'm aware about 6 months to a year ago there was a movement to try and make these questionnaires more relevant and less inconsistent, because if each law firm receives from each client different questionnaires, it's not going to be very helpful. Now, this is where there's an organization that Paul and I are involved in called Lawyers for Net Zero, and that has public lawyers and general counsel. Doesn't have any private lawyers in it, because we thought they might start lobbying the clients. And but the idea was, there was a lady behind it, I'm trying to remember which company she was with, and she said, we must get these questionnaires right. So I would be speaking, maybe through the Law Society and through Lawyers for Net Zero, to say, okay, we need to get these questionnaires right, we need to get them consistent, because what law, and there has to be some communication between what the client's seeking and what the law firm are able to provide, or can provide reasonably. And I think I sympathise with that. But it is important for clients now to make sure that their lawyers and accountants and professional advisors are value aligned with them. And I think we can see the importance of that. I mentioned, I think, lots of scandals really that have happened, and I keep looking for ones for law firms. So law firms must be doing something right, because the accountancy firms and the private consultancies like McKinsey and Bain & Co have run into large problems, whereas law firms don't seem to that often, certainly not to my knowledge. So I think it is important that we get this right. But talk to your clients. It's a new thing.
Yeah. And Paul Clements Hunt, anything to add there?
Yeah, can you hear me okay?
Yes.
Yeah, I'll just briefly, I completely agree with Paul. There's also huge fatigue. It's not just in the legal firmament, but across professional services and across different industry blocks in terms of just pure ESG questionnaire fatigue. Where, a lot of, I think in some ways, conceived with the best of intentions, but delivered in a way where they're not specific enough in terms of the sector or the subsector, and that's an issue. But I flick it round to what Paul said, which is, it's in some ways, I think it's not about the major legal firms or the specialist firms or the smaller firms being reactive. Is be proactive. You should be doing not the questionnaire, but you should be questioning your clients in terms of what they want in terms of ESG services. That's key, because the market's moving faster than many legal players are.
Mm-hmm. One of the things we talked about earlier was greenwash and how that's developing and the way it has developed. And that will become a criminal offence, I'm sure, a unique criminal offence rather than one that's patched together through a number of codes, criminal and, as Paul correctly pointed out, civil. Because you had McKinsey & Co pay over $600 million for a deferred prosecution agreement. Now, that's a very effective way of telling your company to get it right. That sort of money soon becomes a reasonable sum. And I noticed today that there was an article, I think it was in the New York Times, but it was about various companies who had produced green bonds and sustainably linked bonds and loans, etc. And this is where I find it difficult. these bonds and loans will be drafted by lawyers. And not only do they lack any environmental purpose or sustainable purpose, but they haven't got the mechanisms for reporting, transparency, enforcement, etc. And they were some of the largest companies in the world. I just noted down that that Chanel was there, Tesco were there, and they were looking at these bonds as not producing any social impact. So lawyers have to draft those. So we are we're not wholly well, we don't come away from this with entirely clean hands. Let me put it that way.
Right. There was another question that came in the chat box, and this one probably will take us to the end of our time together, but I really would love to hear your thoughts on this. Thinking out 5 years, 10 years, or even beyond, what could the sequel to the Dragon reports look like? What would it look like? And what should it look like, let's say 5 or 10 years from now? And I'll start with Paul Clements Hunt.
It will be a vibrant, dynamic report showing an entirely different legal ecosystem, where from Magic Circle, white shoe lawyers through to the specialists have, well, the smart ones have embedded deep ESG skills, not as a unit, but across every single facet. It will also rank and rate and assess companies in a very direct way, I would suggest, in 10 years' time, in the way that we've had chasing last year, we've got riding this year, next year it's taming the dragon. So this is the softball entree to ESG engagement and the rise of sustainability in law. But that would be my feeling. I think it would be a highly dynamic, competitive area of law which sustains itself because it's a vibrant market. Over to Paul.
Yeah, I should explain I'm speaking from the Yale Club in New York, and I'm over here not only doing presentations, but talking to law firms about how they should be looking at their own practices and accountancy firms. And it's been quite interesting. I spent quite a long time recently with accountants, and they are building up their legal capacity in a fairly major way and spending. Paul, did you want to?
No, you go.
Okay. They are building up the legal capacity. So you've got KPMG law, you've got EY law, you've got Deloitte, etc. But they are doing, which I think law firms are doing to an extent too. I actually see law firms as being much more multidisciplinary, because you do need people who can handle big data. You do need them working with you. You need people who have put their boots on the ground and gone round factories in China and various other areas, like Darkest Leicestershire or places in the UK, where there has been quite a lot of poor employment practices. And I would think that what we're going to see in 10 years' time is a very different legal profession. I mean, I'll just take one example, and I might as well name them, because Clifford Chance are a firm which were, in my day, they were good, but they were sort of middle Magic Circle. And but what I've seen through, and I think you've got Jerome coming to speak, and you might want to ask him this question: how has he invigorated that firm? Because they're doing such good work now across a number of ways, and they still are representing oil and gas companies and energy companies, etc. And I think that will still happen, although I see the opportunities arising for what I call a disruptive law firm. You know, you could have one set up and take all the people who actually know what they're doing in ESG, because companies will, and general counsel, start to find out. And I do know of one presentation went badly wrong because none of the lawyers there knew what a scope 3 emission was. And when you're talking to a major carbon emitter, it's maybe not the best of images. I should stop and let Paul, who's wagging his finger, come in.
Sorry, Pam, I'm just going to do housekeeping. We've literally had thousands of people asking us where Riding the Dragon, the report is. What we've done, and you know this full well, is we couldn't resist the chance to actually take the Legal ESG Summit, and we're going to do the first report back in writing. So that means the report will actually be published in the middle of October now. But we thought it made sense to just delay a little while, give them the fresh Legal ESG Summit. So that will be very well publicized around and about LinkedIn, on Twitter, etc., social media, and people can access it free of charge. There's no charge, and we've got some really loyal sponsors, including Paul, for the process. But I thought it best to let people know.
Thank you. And I'm going to pose one more question, 1 minute response from each of you. And this is a question from the audience. They says, we can't just rely on the next generation to get more engaged in ESG. What recommendations do you have for those of us who might be more experienced and senior? How can we get involved? And we'll start with Professor Paul.
Well, when I was with Freshfields, we did lots of work in the climate change area, in business and human rights, etc. But we had to do it as part of a discussion, and part of it was it's extending some of the pro bono work. I mean, we did the Paul Clements Hunt's Freshfields report, almost costing my partnership. But the thing about it was that it's not a matter of age. You have to talk to your management, and it's a lot easier to talk to management when you get someone like Jerome to tell you about their task force, the way in which they have extended their business, and I can see this. I can see what renewable energy, for example, with Scottish Power. One of the things I did for Scottish Power was they were all coal burning when I started advising them. The time I finished advising them, they haven't burnt coal since 2016. So that's something I'm quite proud of. Although you have to talk to management, and management have to see the potential and the retention, whatever you want to do it. But also, it's a very, very lucrative part of the market, particularly if you know how to do it well.
Paul Clements Hunt.
Pam, look, to finish, two simple points. One is, and as you know, I'm now working with Mishcon de Rea in London. I think for any law firm, you have to go back as the partners to the constitutional documents and revise them in terms of the purpose of the law firm. Mishcon did that. That's one. And I think that's really important. The second thing is that across different practices, senior lawyers, I mean, I think the question was really, it's a challenging question in terms of it's not just about young lawyers coming in and the new generation. How do experienced lawyers look at it? Look, the experienced lawyers, they know their areas of practice. My advice would be, it's not just your area of practice, it's about extending and opening the mind in terms of risk is changing, the nature of risk is changing, those complex converging systemic risks. Look at it systemically, look at it in terms of across your portfolio of clients, and then look at individual clients. You know the risks. It's about extending the way you see risks and understand risk. And if a lawyer cannot do that and be a quick learn as an older, experienced lawyer, who can? Because lawyers are at the center of contention, at the center of difficult issues, helping clients work through them, helping companies adjust to a new reality. So a good, experienced lawyer should be able to take ESG, not learn it overnight, but in terms of their practice lens and their experience lens, should be able to apply the key things. It's simple. It's about material risk. Material risks are getting broader. Ensure that you're in a position to advise as an external, the general counsels, but also empower them to work with their boards in terms of understanding this new world of risk, new world of fiduciary law, roles, responsibilities. Pam, that was, thank you for the opportunity again.
I think that's so spot on. This is our wheelhouse, right? This is lawyers' area of expertise, and we just have to bring that expertise to our clients. Thank you, gentlemen, so much. You never disappoint. Yes, you will be invited back next year. And thank you to the audience for sticking with us. We ran a little bit over, but we will now have a 15-minute break before we start the next session at the top of the hour. Paul Clements Hunt, thank you. Professor Paul, thank you so much.
Pleasure.
Bye-bye.